Hello, good evening, everyone, and welcome to this webinar. Extradition has been making headlines around the world. Cases like Julia Assange, Clara Ponsati, Wenzel Meng, Vijay Mallya, King.com, and just last week we had the High Court's decision in Edinburgh in the case of James Craig. Now, these are various cases of extradition, and notably, you find that in 4 of these 6 cases, it is the U.S. who has been seeking an individual from the U.K., Canada, and New Zealand, and the other requesting cases are indeed Spain and India. But the point is, the subject remains relevant, topical, and important, and it brings together so many different subjects. Whether it's criminal law, human rights, terrorism, nationalism, hacking, fraud, and comity between the nations, and indeed enmity between nations, and so on. However, today we are focusing on 3 of the most high-profile cases, at least from a UK and Canadian perspective. So we're looking at Julia Assange, Clara Ponsati, and Meng Wanzhou. So thank you very much for joining this conversation with Paul and I, and it would be intellectually rewarding to glean from the insights of Dr. Paul Arnell, who is the expert in extradition and human rights related matters in the UK and indeed globally. So I'm mindful of time constraints, and so in dealing with even just one of these high profile cases, much less to deal with 3 of them in the same webinar. So I guess we'll get straight into it. So Paul, for the benefit of those who do not prior to this time have the foundational context of the concept of extradition and of course the individual cases that we'll be dealing with, let's start from the very beginning. So what is extradition and what law governs it?
Well, thank you, Uche. Welcome everybody to our webinar. I'm delighted to see we've got a good turnout of alumni and others who have bothered to come. So Uche and I appreciate it. I'm particularly interested in extradition law and practice, and I've convinced Uche, my colleague in the law school, to fashion a bit of interest in the subject as well. And as Uche said, it's increasingly in the news, and not just the back pages or the law pages, but indeed the front pages. And as Uche alluded to, just last week in Scotland, the High Court of Justiciary refused the appeal of James Craig, a pensioner from the west coast of Scotland who was sought by the US on securities charges. That's just the latest, and it was on the BBC News website. That was on the front page. Who reads newspapers anymore? But on the front page of the webpage. So it's important, and indeed, I think why I'm drawn to the subject is that it crosses over so many different disciplines: international law, the criminal law, evidence, international relations, politics, and human rights, and others. But simply, extradition is the legal process whereby accused and convicted persons are transferred from one country to another. And it's governed in the UK, within the UK, by the Extradition Act 2003, by and large. That's the main law. Canada has we'll mention a bit of this at the end about Canadian extradition law, which I know a little about, is governed by the Extradition Act 1999 in Canada. So each country has their own regulation internally, and between countries, of course, there is treaties, of course, I think you would know, bilateral, by and large, extradition treaties, and between the US and the UK, a well-known one and controversial one dating from 2003, and again an elder one between older one between Canada and the United States from 1976. So it's a process that governs the transfer of convicted and accused persons, governed by both national law and international law.
Right. Yeah. Thank you. Thank you for that. So just to look at the extradition proceedings itself, I believe the core objective in an extradition proceeding is, at least in the UK, would be to determine whether there is dual criminality. That is, whether the allegation against which the accused is facing is a crime both in the states that has requested the accused, as well as in the states from which it is requested. Now, with regards to dual criminality, and of course the issue of whether there is a bar to the extradition request. So let's look at these two things before we go into the issues at stake. What are some of these statutory bars that could hinder an extradition proceedings, to be successful?
Well, you were right in that the sort of the centerpiece of extradition practice in certainly in the United Kingdom, less so in Canada, but there still is a hearing where a judge would preside, a sheriff in Scotland, a district judge in England, in Wales, preside, and we'll speak about the UK alone just for a moment, where that judge would consider bars to extradition and other aspects of extradition law, which the bars, which if anyone is successfully invoked, the requested person will be discharged and so not extradited, and so would not have to face the fate, and an ominous, very serious fate it is if you're sought by any country abroad and then physically put on an airplane and sent to that country, most likely away from your, possibly away from your home and family and friends and your familiar surroundings and indeed familiar legal system, perhaps, to be held pending trial. So there is this hearing, and at the hearing in the UK, there are grounds upon which a hearing could be, the grounds could be successfully invoked, so that it would lead to the discharge of the person. And you're right to say double criminality is one of them. That's not a bar to extradition, but it's just a facet of the procedure that an individual will only ever be extradited if the crime at issue is unlawful in both the requesting and requested country. And we don't want to spend too long at the introduction, or we'll run out of time. But that has arisen in most of the cases. I think it could arise in all three of the cases that we'll come on to and briefly discuss. And there are other ones, high-profile ones, including a new type of political bar. It's not a political offense exception. That no longer exists in UK law, anyways. But there's a political type bar, as well as human rights, one of the most well-known grounds upon which opposition to extradition can be argued.
Okay. So basically, you're saying that some of these bars include, like you said, the political bars, as you can see in the Extradition Act of 2003. And then, of course, the human rights, and then the oppression ban, a number of other bars. So let's discuss them with regards to the cases in view. Let's look at Julian Assange. Let's start with him and find out who is he, and what are the latest developments in his case. And seeing as you've already started talking about some of these bars, it'll be helpful to just give us a brief background to him and what the context of this case is about.
Okay, yeah, I think that's a good idea. I can sort of flesh out some of the more substance of extradition law through the example of the two UK cases, one being heard in England and London, and the other one in Edinburgh, and then the Canadian case at the end. Julian Assange is a 48-year-old Australian national who is presently being held in Belmarsh prison, having served a sentence for breaching his bail conditions some time ago, as regard an earlier extradition request from Sweden. That sentence has been served, but now he's being held pending the conclusion of his extradition hearing, which the latest aspect of which took place in February this year, where not in the normal Westminster Magistrates Court, but in Woolwich Crown Court, unusually, I think purely to accommodate the the scale of that hearing and the interest it generates. The first part of his extradition hearing took place, where lawyers both representing the U.S. government and lawyers representing Julian Assange himself laid out the arguments that they are putting forward, both in favor of his extradition and in opposition to it. And just in May originally was scheduled the second part of the hearing, where evidence would be led by those who, in a number of individuals in different areas and disciplines and different expertise, to speak of, say, sentencing practice in the U.S. or the political context of the charges against him and so forth. But with, as we all know, around the world, the COVID-19 has thrown a spanner in many works, and this is one example. So his extradition hearing has been put back until September this year, where it will start again. The sort of second part where his lawyers will lead evidence, his lawyers and lawyers for the U.S. government, in support of their positions in his extradition hearing. So that's simply, I think, where we're at. But during the first stage, or the first part of his hearing before it was suspended, as I've said, the lawyers put forward arguments, and some of them I've mentioned already, but they laid out the grounds upon which they will further build upon and expand in subsequent parts of this hearing.
Okay, let's sort of zoom in on some of these arguments now. Now, this is a gentleman that has been sort of held out as like an anti-war, anti-imperialism champion of political transparency. He sort of provided information on issues such as war crimes, torture, and mistreatment of Guantanamo detainees. Now, could you say that, now it's a bit of a long question, but I'll get this. Could you say that political opinions extend to those which are sort of imputed on the accused by the state which persecutes him? Because there has been characterization of Julian Assange and WikiLeaks by then director of the CIA and the current Secretary of State, Mike Pompeo, in the United States. And he said that WikiLeaks and Julian Assange are pretty much a non-state hostile intelligence agency. Now, he said this in April 2017. Now, if you going off from the argument you made initially about it being barred under Section 81 of the 2003 Act, if you look at the exact wordings of that particular provision, it actually envisages that there could be an appearance that the extradition request is made on account of the extradition offense, while in fact it is made for the purpose of prosecuting or punishing the accused on account of, in this case, his political opinions or nationality. So would it be a good argument to make that this is directed as him, because of his political opinions, and which some may say have guided his actions?
Well, that's a very big question. I guess I get back one thing I overlooked to mention is that, of course, he's been charged. I mentioned who he was, but he's been charged in the U.S. with I think was it 17 separate or 19 counts. But he's charged under 2 indictments: one of computer hacking, and one of espionage in the United States under the Espionage Act 1917. So those are the 2 crimes he's been charged with in a number of counts of those crimes. And so that's what's one of the things that are going to arise. Well, I guess all of the issues are going to arise around those indictments against him. But to answer your question, well, in one sense, what he has done is political, but I guess the question is that the district judge will consider is whether the terms of, you're right to mention, the bar to extradition on this ground on political opinions is found in Section 81 of the Extradition Act 2003, and so they're not interested in maybe broader pictures of American or supposed American imperialism, or unlawful renditions, or egregious treatment of civilians in Afghanistan or Iraq. They should be, perhaps, but that's not the issue facing the district judge. It's whether the terms of and on this ground we're talking about of Section 81 are met. And just ever so briefly, there's 2 grounds under Section 81. Number 1, the request for, say, Assange's extradition, though purported to be made on account of the extradition offense, say espionage, is in fact made for the purpose of prosecuting or punishing him on account of his race, religion, nationality, gender, sexual orientation, or political opinions. And so the question is the United States seeking his extradition to punish him for his political opinions? And I would have thought the answer to that question, and there could be a big debate on this, but I would say no. They are seeking to punish him for espionage, and that's a different thing. And you could say, arguably, his political opinions are his motivation for undertaking the work he has done, but a motive is by and large neither here nor there for the criminal law. It's what he's done, and he's not being punished for that motive. He's being punished for what he had done. And so I think that argument is certainly tenable. I think, and I will probably think more generally, we're already running out of time, that his arguments will have some merit on their face or unlikely to be successful.
Okay, so I just do one or 2 more questions on Assange, and this is perhaps on the second bar, which is really around Section 87 of the Act, and that deals really with the human rights issues, and you have issues like fair trial, torture under fair trial under Article 6 and torture under Article 3 of the European Conventions on Human Rights. Now, these are issues that sort of cross, that have such interplay amongst themselves. Now, looking at the potential maximum sentence for the espionage indictment that he has against him and the Computer Misuse Act, it totally comes to about 175 years for the offenses, amounting in effect to a life sentence. Now, this sort of straddles the Article 3 line because, looking at it in the context of a supermax prison in the United States. So if we assume that this maximum offense may never be imputed to him, could it be used as a persuasive factor, to sort of succumb him to a plea bargain? in noting that plea bargaining is something that's common within the U.S. justice system. And would that not be viewed as putting him at risk of being exposed to a flagrant denial of justice as stipulated under Article 6? And then, also under the B part of Section 81, which says that extradition might be barred if the accused might be prejudiced at his trial or punished or detained by reason of his nationality and political opinions.
Well, thank you. That was a loaded question. You had about 15 different aspects to it.
I just pushed all together.
Yeah, I know. We have to do that. I mean, we'll have to. We could be here all night. But you're right to say, I guess, the first point, human rights arguments are certainly tenable, will certainly be put forward in bar of his extradition. I think under Article 3, certainly, right to be free from torture or inhuman or degrading treatment or punishment, right to a fair trial under Article 6, right to, arguably, right, Article 8, right to respect for private and family life. And then I think was something we mentioned in our original webinar several months ago, Article 10 as well, a right to freedom of expression. And certainly under those first rights, 3, 6, and 8, there's developed jurisprudence by the European Court of Human Rights and by courts in the UK, which have devised tests under which those entitlements can be successfully invoked or not. But to briefly mention your sentence point, there has been jurisprudence where individuals were facing a life means life sentence in the United States, where the only way you're leaving is in a coffin because you're not going to be let out prior to that point in any circumstance. That jurisprudence has developed ever so slightly in the European Court of Human Rights. My understanding now is that an absolute life mean life sentence is contrary to Article 3. There has to be some prospect of release and some procedure, even if it's an exceptional sort of commutation one by a presidential pardon or some other system in the United States. But a life sentence in itself is not a violation of Article 3. So, and that's even, assuming, which I don't think is the case, that such a sentence would ever be imposed 175 years. I've been doing some reading about that, and I think that's very unlikely. But even if it was a life sentence, it would be not such to give rise to a violation of Article 3 and thus bar his extradition.
Okay. Thank you. Perhaps I can just squeeze in one more, then we go to Ponsati.
Okay.
So another argument that was levied was the Section 901 of the Extradition Act, which actually prevents his extradition on account of his physical and mental health or the risk of suicide. Could you shed more light on this, oppression bar?
Yes, and again, I think this is what we mentioned last time we spoke about it on a webinar that might be then, and I'm still that way inclined, is that might be an argument that has the greatest chance of success. I don't know if any of the people watching it saw the footage when he was taken from the Ecuadorian embassy back in a couple of years ago, 2017 was it? And he was looking frail and I've been affected clearly by his stay in there and lack of fresh air and so forth, and only can assume his stay in Belmarsh prison is not doing his health any favors. And so if it comes to a point where his health deteriorates to such an extent, that may well be upheld, and there's a relatively recent precedent that, although in different circumstances, and that's the case of Lori Love, whose extradition was barred in part because of Section 91. But what may happen, though, if he argues his mental or physical health, is then what is to be expected is that the United States will give assurances to the UK to suggest he will be treated in this manner. He will have access to psychiatrists or medicines or a certain type of cell accommodation to obviate, as far as possible, the most detrimental aspects of that whole process and of incarceration in the U.S. and to mitigate as far as you can the health problems. So make it, as much as you can akin to what's here. So that is what may happen in that argument.
Yeah, but just about in just on that point before I move on to the Ponsati, there has also been instances where this kind of argument has been unsuccessful. If you take the case of the Wani case in South Africa, where he also made like arguments, and the position was that if South Africa could give the assurance that they can also provide the kind of care that could have been provided in the UK, and that very much applies in this case, because whatever mental or physical health conditions could also be catered for in the UK as it would be catered for in the US. So how do you deal with that?
Yeah, well, that's a good example, and I said that's what's most likely would happen is that if it comes to that, and there's concerns by the district judge about that point, assurances can be sought from the United States, who would then, if the concern is, say, mental health or indeed all aspects of it. There has been jurisprudence about that. Indeed, the transfer process, the way you're detained prior to trial, the medicines, or psychiatric assistance and so forth. So I imagine, and I guess this boils down to one of the reasons the U.S. can make these requests so regularly is that they're relatively well resourced and with lawyers and others, so they could answer that with assurances that would. I know there's been criticism of the assurances are made, and then once they're made and they have the individual, they're not upheld, and there may be a slight degree of merit to that, but there is a whole there has been attempts to ensure that assurances once made are indeed abided by. Okay. I think we're going to have to move on, Uche. We already got
just to Clara Ponsati now. Yeah, we're just going to go to her now. So could you just shed light a little bit on her case and what arguments might she put forward, or just give a context to her case and what her potential arguments would be?
I'll do that, and it'll be very quick because we've set out a lot of the the relevant law, or some of the relevant law, and sort of the framework already. But this is a very interesting Scottish case that Professor Ponsati is a professor of economics and former head of school of the School of Economics, I think, at St Andrews University in Scotland, a Spanish national, and she was education minister of a putative Catalonian government prior to the independence referendum there held in 2017, which was unlawful in Spanish law. And I think the votes cast were in favor of, I think slightly in favor, maybe even more than slightly, but were in favor of Catalonian independence from Spain. But the turnout was, I think, maybe 50 or 60%. Someone maybe could correct me if I'm wrong in my statistics. But anyways, the material facts are that she was the education minister in that government in waiting, as I guess you could put it. And then subsequently Spain sought her request twice. The second request is still pending, and the hearing had begun in Edinburgh Sheriff Court, in front of Sheriff Ross, and but it has presently been suspended because, interestingly, a facet of the UK's exit from the European Union has been the reallocation of seats in the European Parliament. Spain was given several, I think, I don't know how many, but a more than one, given some, and she was at near the top of the list for that, and so she is now a sitting member of the European Parliament. And a question has arisen whether, as such, she is immune from criminal prosecution in Spain. And so what has happened is the sheriff in Edinburgh has suspended her extradition hearing pending a decision of the European Parliament on her criminal immunity. So that's where we stand. A very interesting and different, very different case than Julian Assange.
Yeah, okay. One more question on hand, and I go to Meng. Now, her case is really premised on the European arrest warrant now, and so that's sort of relevant. What will be the fate of the extradition if, well, after the transition period of the UK leaving the EU, after the transition period of this Brexit situation, because that law may not longer be applicable in the UK. What's your take on the relevance of that and how that would work out?
A very interesting question. Of course, as I think we all know, the UK has left the EU, the transition period until the end of this year. Governing intra-EU extradition is the European arrest warrant scheme, a sort of a fast-track system devoid of political involvement, a judicial surrender exercise, not a sort of a traditional form of extradition, which we've already mentioned has judicial involvement, but ultimately a political decision, lesser so in the UK than Canada now, but ultimately the final decision is made by a politician outside the EU. As things stand, and of course, all of the Brexit negotiations have been well, either under the radar or overtaken or suspended. I don't think they've restarted. I've heard a little bit about them, but they've been pushed off the front pages in any event by the pandemic. But I know there has to be, well, there has to be negotiations. There has to be a deal of some sort, or I guess that's not even accurate. But if there is no deal, the situation is such that intra-European Union extradition will fall to be governed by the European Convention on Extradition 1957, sort of an old-fashioned system of extradition. And the UK's provided for that already in its law. Importantly, a number of other EU members haven't, and that sort of law is no longer on their books, and so that's an issue. But my understanding is, and I may be wrong about this, so this is just my understanding, but I think, is that considering her case is up and running, and I think it would continue as is, even after the 31st of December. But I guess I'm not 100% sure of that, and that could be something to be discussed. Or indeed the transition phase, which may be extended further. I mean, I know the present Conservative government has said that that's not a possibility, but it may be calamitous if it's not. So I don't know is the answer to that question for sure.
Yeah. All right. Quickly to Meng. So who is she? Why is she in the news? What are the recent developments in her case? And particularly in relation to the issue of double criminality, it will be helpful if you could shed more light in her case with respect to double criminality as well.
Okay, great. So this is our third individual that has been in the news, and it has made papers or websites in the UK, but of course more so in Canada. I read Canadian newspapers, and it's a big story there. She is the chief financial officer of Huawei, one of the leading largest telecommunications companies in the world, a Chinese telecommunication company. Her father is the founder of that company. She's the chief executive officer. She was arrested in Vancouver maybe a year ago or so now. I don't know the exact date of that actually, but she's been arrested some time ago en route, I think, from China to South America, I think. The UK has, the United States has accused her of acting in violation of American fraud, but following violation of sanctions that the US has imposed against Iran. And so that's what's happening now. She's under house arrest. She's got an electronic sort of tag around her ankle, staying in one of her two big nice houses in Vancouver. I shouldn't make light of that. I mean, but that's where she is now. She's not in prison. She's tagged on bail in Vancouver. And the first stage of her judicial proceedings has just finished 2 weeks or so ago. where the British Columbia, the province of in which Vancouver is, has decided that the double criminality principle in Canadian extradition law is met. So that sort of paves the way for her continues to pave the way for her extradition from Canada to the U.S.
Okay. Okay. So finally, before we get we take questions from everyone. Looking at the UK outlook on extradition, it's really hinged by the need to cooperate with states around the world and also to protect. But looking at all of these, how much of these cases, now all three that we have discussed, how much of these are really politics or law? Looking at it, how do you differentiate between, which is politics, which is law? Is Assange considered is a heroic journalist, or is he just a spy and a villain who has caused considerable harm to the national security in the U.S.? Or is Ponsati a patriot, a defender of the Catalan identity and independence? Or is she just a criminal who broke the Spanish law? And same with Meng. Is she a very successful, accomplished businesswoman, or is she just a criminal who knowingly evaded U.S. sanctions on Iran, perhaps as a tool of Chinese state power? So where do we draw the line in sort of honing all of these in?
I guess that's a massive question, and I suppose a very controversial one, which I'm sure our audience out and people around the world have got divergent, probably maybe strong divergent views on that issue, but on those issues. But I would say those issues are sort of political ones, and extradition by and large doesn't concern itself with it. As I've talked earlier about motives, I mean the motives of Ponsati, the motives of Julian Assange, and indeed I suppose the motives of Meng are not material to their extradition. I mean, they may have some bearing on it. Extradition is this legal procedure, and what the judges in Canada and the UK are doing, or seeing if these these intricacies, these bars and other rules. We haven't mentioned prima facie case. This is going to be the next stage in the Canadian judicial proceedings, and whether these particulars of the law are met, and then if they are met, the person will be sent. And I guess underlying extradition is a trust between parties, right? Because these are bilateral treaties where Canada has entered in with the US, and so has the UK, and there's a degree of trust and acceptance between the two, and reciprocity. So they want to, the whole nature of the agreements is to cooperate between countries. And if there is a ill will or mistrust between the countries, of a requisite level, a treaty wouldn't be entered into in the first place. I can think of, say, Edward Snowden in Russia. Obviously, between Russia and the U.S. right now, there are not viable extradition relations because of the degree of mistrust and lack of cooperation between the two. But that doesn't exist between, say, the three countries we're speaking about now. And so I think the answer to that would be pretty judicial extradition hearings or judicial decisions are not concerned with those issues. What would happen, I suppose, is if an individual, if Julian Assange or Clara Ponsati, if her case does continue and she is sent, it's down for the Spanish court or the American courts in Meng's and Assange's case to decide whether the criminal law in those countries have been broken. And it's for maybe us, even though I'm not answering your question you asked me, or commentators or media or politicians or campaigners to decide and to canvass. And I know, and every time there is a hearing in Julian Assange's case in London, there's a number of protesters making their views known, that they think this what's happening to him is unfair, is egregious, is they're silencing an individual who has exposed, serious ill treatment, torture, and other misdeeds by the United States abroad, and in no way should that person be indeed held in bail march or sent to stand trial for that exposure in the U.S. But as I say, the district judge is not going to be seized of that specific issue. She's as a lawyer, as a judge, is applying the law. Right. That may be a fudge of an answer. Sorry about that.
That's okay. That's a